So I just want to welcome everybody on behalf of the Academy of Trial Lawyers and introduce today's Ask Me Anything responders, I'll say. We have Paul Isaac and Paul Loudenslager, both here from Academy sponsor Precision Resolution, as well as Paramount Settlement Planning, their settlement wing, here to answer all of your burning questions regarding liens and settlements. They're a long-standing Academy sponsor, basically backing the organization since we were founded, and all of our big missions have always seen Paramount and Precision behind the work that we do. So we really appreciate their support and absolutely the longevity of their support. And we appreciate having such great experts to refer our members to when they have these types of questions. So I will turn it over to our emailed questions to start. And folks, if you have any specific questions you'd like to pose to our presenters, please do pop them into the Q&A, which is accessible at the bottom of your screen. If you're having any difficulty, just email them to us, info@trialacademy.org. That's what we got a few here. So I will get started. Question one for Paul and Paul. My client is on Medicaid, My client is on Medicaid. It is their only insurance, and I know they paid for treatment. However, Medicaid did not put me on notice of any lien. Do I have an obligation to reach out to Medicaid?
Two things. One, I think, and first, if you're obligated by law under CPLR 306C to put the Medicaid agency on notice if you represent someone who is a Medicaid beneficiary and you are filing suit. So that's the first step. If the case is not in suit, that opens a completely gray area. First of all, let me go back. I want to say that the law 306C and 104B requiring notification to social services in the event of a lawsuit on behalf of Medicaid beneficiary don't have any consequences associated with it. So it's not like there's a penalty. But I will say this, in the many motions that we've made over the years, we're in a lot better position to address the Medicaid lien when we have followed the rules, and we're alleging that they did not follow the rules. Okay, it's a little bit of an equitable situation where we said we put them on notice, they didn't notify us, and we're in a better position. Do you have an obligation? I think if you look at 1.115 of the disciplinary rules, if you know someone has an interest in a case, you're required to address that interest. However, Medicaid's interests are contingent upon them following the guidelines that are set forth in 104A or 104B, sections 2 and 3 and so on and so forth. There's a lot of requirements there. So do I think that doesn't mean that they can't bring a claim at a later date? 104 of the social services law allows an agency to bring a claim against any Medicaid beneficiary who is found to come into money. Does that happen often? I don't know if I've ever seen it. Have you, Paul?
No, I haven't seen it, but to kind of go further on that point, no question, if you have filed a lawsuit, there is an obligation affirmatively to notify Medicaid under the statute, under the CPLR and the social services law. If you have a case that's pre-suit, like Paul mentioned, rule 1.15 of the rules of professional conduct, puts plaintiff's counsel in a really difficult spot, especially considering how these Medicaids really work. They're really based on an automatic assignment under the social services law, whereby your client, as a condition of eligibility, has assigned to the state or to the local Medicaid agency their rights to payment for medical care. So to the extent that any portion of your settlement may include compensation for medicals, arguably your client has assigned that portion to the state Medicaid agency, And so Rule 1.15 is triggered where you have an obligation to notify once you receive the settlement proceeds. There's an obligation to notify third parties that might have an interest in those funds.
Yeah, practically speaking, Paul and I both know that if a plaintiff does not have a lien filed against them, and there's no notice to plaintiff's counsel, and we're settling a case, you're settling a case for, 25 grand, and there is no medical component on the case, 99% of the attorneys who talk to us don't go searching for the Medicaid lien. Is that right, Paul? It's basically, it's close the file and move on. Because, sort of the lien evaporates after the case is resolved. There's a lot of difficulty for Medicaid to be able to pursue that. But again, their lien is valid if they follow the checklist, and as Paul said, there's an automatic assignment. When I say those $25,000 cases, because 9 times out of 10, there is no medical component of those cases, right? Your client's got even $100,000 case, your client's got far worse injuries and there's no medical component of the file. One other thing to be very, we have to bring this up. In a situation since 2014 under the Affordable Care Act, in many cases, the actual treatment is subbed out to, or the payment for treatment is subbed out to a private contractor such as Fidelis or someone like that. And those companies who actually pay the bills have no rights under our current law to recover. So it's just the Medicaid agency, most of the time, having capitation rights or rights to reimbursement for the payments that they made on a monthly basis to the Fidelis or whoever the entity is. And sometimes they don't amount to much. And sometimes if the case drags out for 10 years, they amount to more than the medical treatment. Practically speaking, where folks don't have notice of the Medicaid lien and they haven't put it in suit, very few people that I know go search out the Medicaid lien. Warn your client that they could come back and bring a lawsuit, do all that, but there's no perfect answer here on these questions, but I'm just telling you what most people do. Paul, anything to add? By the way, this is a question we get probably 4 times a day.
Yeah, right.
They tried that route with his, so he got the local route.
Shall we move to the next question? All right. The next question was emailed in from Laura in Albany. Question 2, we settled the liability portion of a case and reported settlement to Medicare already. We expect the SUM portion to settle in the next month. Do I need to report the SUM settlement to Medicare?
Paul, you can handle that when you remember.
Yeah, the answer is yes. SUM recovery is considered a liability insurance situation according to Medicare's definitions. Anytime you have a liability insurance payment to a Medicare beneficiary, there's a potential conditional payment issue there. I think the regulation is 42 CFR 411.24. That includes some coverage in the definition of liability insurance, but yes, basically, when you have those situations where you collect the underlying third-party policy and then there's SUM coverage available that might not come until a month or a year down the line, there's basically two separate processes with Medicare. Get the conditional payments, close out file number 1 on settlement number 1, and then do the same on settlement number 2 with the sum portion.
Probably the second most frequently asked question of us, other than the previous question. One thing to add to that too, Paul will tell you this, that your final demand letter will say right on it, if you receive another settlement, you must report that settlement related as well.
Excellent. Glad we're starting off with some good all-encompassing questions. We do have a couple that popped up in Q&A, so I'm going to move to that for some folks watching live. This question's from Andrew Fiore. What are the duties and obligation in a pre-suit settlement where the plaintiff has a judgment against him for child support through DDS? Is it a violation of my duty to my client to seek it out? And do I have any obligations statutorily or ethically?
I think you go back to section 1115 of, and look at comment number 4 of the disciplinary rules. It will tell you that if you know that there's a lien, and the question is, how do you know, right? If you've been put on notice of that lien or your client just references it, they're two different things. I think if you've been put on notice of a child support lien, and I back in the early days after law school, I practiced a good bit of family law. I don't know that there's an actual command in that notice. Maybe the letter has changed a little bit. If it's directed to you, then I think you have to obey it. If it's not directed to you and your client just tells you, "Look, I owe child support," well, that's not your problem. I don't think. We are not specialists in child support. In those types of liens, we deal with primarily medical liens, occasionally a hospital lien, but we deal with Medicare, Medicaid, ERISA, FEBA, federal employees benefit plans, veterans plans, all those plans, but we do not deal with the child support liens because that is such an intricate and distinct area of the law. Oftentimes, as I recall, the child support lien number was overstated because there had been payments made or deductions taken from Social Security or something like that, and they haven't caught up with them. So I think there's a lot of much more ambiguity there. I don't think that you have to go out and search it if you haven't been put on notice. I don't know if you have a different opinion, Paul.
I mean, child support is your client's obligation. I don't think necessarily that the ethical rule is triggered upon receipt of settlement proceeds.
Right.
Because the claim is really against your client and not against that specific pot of money.
That's great. That's very true, Paul. Yeah, I overlooked that. Yep. Okay, great.
So, I mean, if you want to be extra careful, I think, and you know about the child support claim, you may want to put it into a letter enclosing the settlement check that reminding your client that they have an obligation for the child support payment and that the proceeds themselves are not, exempt funds from that obligation.
And that all changes if you get a lien letter yourself, and we're saying, you have a case, here's notice of the lien, and you have to abide by it. So, anything else, Kate?
Excellent. I was going to move to the next question if that's sufficient for this one. Excellent. This question again from the Q&A from Suzanne Merrill. She says, what about when the plaintiff receives care from the VA regulations spouse be responsible in any manner?
From the VA regulations spouse.
It's a little unclear.
I did not know. Oh, so family coverage from someone who was a veteran. Yeah, and there's a lawsuit pending, and the claimant is the spouse of a veteran who has been provided medical care. That's probably not through the Veterans Administration. That's probably through some insurance like TRICARE or something like that.
Okay, she did just follow up to clarify. She said, is the spouse responsible if care either ED from VA? She did not mean regulations. She says was a typo.
Is this okay,
so I don't know necessarily that anybody is entitled to care of the VA.
I'll give you in and out quick.
So generally, I mean, let me just tell you generally about the VA. The VA has a right against a third party. It is not really a claim. Let's just say it was a typical Veterans Administration case where the Veterans Administration had provided in the hospital or through payment from an outside hospital had provided coverage. In that situation, the VA has to claim that is against a third party who caused the injuries, and that claim is not eliminated by virtue of your signed release. That claim continues for 6 years from the date of the last payment for medical expenses in a typical VA case. How that would translate to a spouse. So if the I'm going to imagine, I'm going to go out into space here a little bit. If the spouse was the victim of a personal injury accident and the veterans paid for that through by virtue of the other spouse's role in the government, I would think that the claim would only be against the third party, and I don't know how they would come back after the innocent spouse, the non-victimized spouse, the non-injured spouse for those proceeds. I've done the best I could with that.
Wonderful. Thank you very much, Suzanne. I hope that helps. If you have any follow-up, put it in the Q&A for us. So we'll move back to some email questions. This is from John A. in Brooklyn. He writes, I've heard that the New York General Obligations Law, Section 5-335, is not preempted by federal law governing ERISA-type plans, in parentheses, citing Wirtz v. Rawlings. You got that?
No, well,
Wirtz v. Rawling, Second Circuit 2014, concluding, quote, because New York General Obligation Law Section 5-335 is specifically directed toward insurers and substantially affects risk pooling between insurers and insureds, we conclude that it is saved from express preemption under ERISA Section 514 as a law that regulates insurance, end quote. The United States Supreme Court has implicitly affirmed the Second Court's findings. Is ERISA liens in New York State based upon this case? Thank you, John, for your question.
Listen, this is a common area of confusion. So Paul Loudenslager, let's say he works for my company, and instead of so he works for me, so I'm covered by ERISA. It's every relationship we have pretty much is covered by ERISA, but Paul gives me a couple bucks every month, and I take a couple bucks from my company pocket, and we buy health insurance, and that health insurance takes my premium and accepts the risk for all of Paul's maladies. Okay, they must pay for those maladies. That is risk sharing. That is insurance. That is what was dealt with in Wirtz. Don't get them mixed up. From if Paul worked for Verizon, okay, a company with thousands of employees, the Verizon company is not going to spend money and waste money on buying premiums for people that are healthy. They will take a little bit of Paul's money and a little bit of their money and put it into a trust account and privately pay and take the risk on themselves for those medical expenses. That too is ERISA, but that is self-funded ERISA. So our entire relationship is governed by ERISA, whether it be he works for me or he works for Verizon. But one of those two involves an insurance policy, and that type of coverage is not lienable in New York, absolutely dismissible as a claim. The Verizon claim has to be dealt with because they have they're self-funded, and the United States Supreme Court has said that the terms of a self-funded arrangement are enforceable as if it were the law of ERISA. Upsetting, very disturbing, but that's the law of the land and has been since the Sereboff case of 2006, reaffirmed in 2013 by U.S. Airways versus McCutcheon. Yes. So anything you want to add to that, Paul?
Yeah, no, I mean, the Wirtz case is really, my best advice is to just disregard it as superfluous, because really what we're dealing with is a situation that's been the same since 1990. The Supreme Court in FMC Corporation versus Holiday said that the key distinction really is between whether the plan is insured or self-funded, with which Paul just talked about. For self-funded plans, FMC said those plans are entitled to federal preemption, and the federal ERISA statute applies, and therefore, basically by extension, the terms of the individual ERISA plans apply. If the plan is funded with insurance, there is a special exception under the ERISA preemption statute, which says that any state laws regulating insurance are saved from preemption, which is where GOL 5335 comes into play. So any case where you have an employer-based plan, the question is whether it's an insured plan or a self-funded plan. If it's insurance, our state law is saved from preemption, which means there is no right of reimbursement under 5335 of the GOL. If it's self-funded, you have to look to the terms of the health plan to determine what the extent of the plan's rights are.
So here's a good policy for everyone to begin to put in effect. Don't use the term ERISA in isolation. It's because those plans that are dismissible are still covered by ERISA because they're related to our employment. It's self-funded versus insured plans. Self-funded versus insured. Insured plans are dismissible. Self-funded plans are entitled to enforcement. Just the way it is. We don't like it. We fight them every day. We look for that misplaced comma or period or a heading or something to challenge their language. But they are, if we can't find, they're more difficult. And if it were an insured plan that would come into our office, we just would not pay attention to it and tell them you get nothing. So. Any other follow-up?
Good. Ready for next question?
Sure.
Thank you both. This is from our friend Phil Urban in Buffalo, North Buffalo. Question 4, we cannot settle a case for $500K because defense is demanding that my client do a Medicare set aside. My client is on Medicare and will likely treat again in the future, in parentheses, removal of pins in leg and some revision surgery and PT. My client doesn't want to put any funds aside. I want to get the case settled. What do I do?
Well, I'll take that, Paul. You don't mind?
Yep.
So there's no law that requires a Medicare set aside in any situation. What the law says, and it is the what the law says is Medicare will not pay for medical expenses in the event that someone else is responsible for those expenses. And responsibility is oftentimes determined by a release that includes the waiver of all future medical, claims against that particular defendant. So, so there is no law that requires a Medicare set aside in any case. There are people in various industries, including the structured settlement industries, that that push Medicare set asides in every case. Every time there's a Medicare beneficiary, and they're frightened the insurance adjusters in those cases. That doesn't mean you shouldn't have one. It doesn't mean you shouldn't advise your client to have one. The first trigger is always this. One, is there a workers' compensation component to the case? If there is a continuing obligation by the defendant, by the workers' compensation insurer to provide health care related to that accident for the rest of that person's life. Pay for it. If you are waiving that in any fashion, if you were somehow getting a Section 32 and using it to reduce the lien, then your client is benefiting from that transaction, and there should probably be a Medicare set aside addressed. In the event of a pure liability case where there's no workers' compensation involvement, it still would be prudent for a couple of reasons to engage in MSA computation, but it's not required. Understand, I'm saying again, it's not required. So, so why I say that it would be prudent is because once someone is on Medicare, they're not eligible for any other kind of insurance through the exchange. Medicare is exclusive, is the exclusive remedy. Once the Medicare and the exchange was put in place to protect those who are not eligible for Medicare. So if your client chooses not to go forward with that, then there ought to be a strong letter saying, hey, look, this means you may not get Medicare coverage for this, and Medicare could deny coverage for your pins and rod removal, et cetera. You should not be prevented from settling the case because of that, because there is no obligation or exposure to the defendant unless they are a workers' compensation carrier. In order for them to have exposure to Medicare, they must be a primary payer. Primary payer is exhibited by, well, for instance, the workers' compensation statute making them the primary payer for the rest of this person's life, or two, a release that indicates in some way, either explicitly or implicitly, that they're being released from obligation to pay for future medical benefits they may otherwise be responsible for. We've written a number of articles on this. We have a lot of writing on this. No one should be compelled in a liability case to be prevented from resolving a case because of a Medicare set-aside issue. There's some case law out there that, Phil, if you want to email me, I'll be happy to send it to you. This is a daily request as well. So some of the carriers, like I won't mention any names, have that in every single release. So if it is a medical malpractice case and it is in the Buffalo region, I'm fairly certain I know what is causing or who is behind that Medicare set-aside requirement. But in any event, feel free to email me directly and I'll see if I can help you address that issue.
Excellent. Thank you so much, both of you. It is 3 p.m. Would we like to do one more? Should we wrap it up?
No, do one more, sure.
Excellent.
Love to. Can't. I love it.
I know you love this stuff. We do too. We appreciate you being here. All right, let's see. Here's the next one. We have an itemization from Medicaid, and every month there is a line item for capitation payments. What are they, and are they entitled to reimbursement for these payments?
So we've addressed that previously a little bit. Paul, you want to talk about that?
Yeah, I think I figured that out. I just, get the.
Yeah, so the capitation payment is
Sorry.
a fairly new
Just wrap it up, we'll be
development
done.
where basically you have, instead of the Medicaid program paying the providers directly in a fee-for-service situation, you have this capitation situation where they pay a monthly premium, basically called a capitation payment to, United Healthcare or Fidelis or WellCare or Blue Cross Blue Shield or whomever that offers these types of plans, which are called Medicaid managed care plans. And in exchange for those capitation payments, that private insurance company is on the hook to pay the actual medical expenses directly to the providers. So in those situations, the actual medical expenses that are paid by those private carriers are not subject to any kind of a lien. They fall under the general insurance, which is subject to the General Obligations Law, Section 5-335. But to the extent that those benefits are funded by the state Medicaid program through these capitation payments, those capitation payments under the social services law are considered medical assistance, which is a defined term. And to the extent that your client sought any accident-related treatment for any given month in which that capitation payment basically funds the coverage from the private carrier, Medicaid itself will charge as a Medicaid lien the cost of that capitation payment for the month.
It's Sullivan County, state of Monil or
Sullivan County. Yeah.
State of Marmol. I'll get it right.
Yeah.
Marmol, right. So, okay, and just Kate, to end everything here, is it possible that I could share my screen for a second?
It is, and we have one more question from Robert LaPlante in the Q&A
Okay.
that I'm happy to take. We still have almost 100 people watching, so.
Okay, so here's, I'm gonna share a screen here. I'm gonna pull up.
Yep, go ahead, and then we'll address Robert's.
See this part right here? This is, can everybody see this? This is the social services law 104B. It gives the social services agency a lien, including the total amount of assistance and care furnished by such public welfare official between the date of the injury and the settlement, right here, okay? Now, to me, that's where this capitation fee, because it is part of the assistance and care furnished from the date of the injury forward. So that's a 104B lien for that reason, and also because Paul said it's for medical assistance. We're still looking for the right case to challenge this. That doesn't mean we've given up on it, but the one case that has challenged it was unsuccessful, and it was determined to be medical assistance. The other thing I wanted to show just briefly is this is the statute 104, section 104, that says recovery from a person. This public welfare official can always recover from a person discovered to have property. So that's it. I'm going to go next question.
Thanks, Paul. All right, Robert writes, with regard to paying Medicaid lien, you are charged the capitation rate. If you find out the cost of the individual medical expense, can you pay that singular expense, or are you still obligated to pay the capitation rate?
I think we just hammered that, but go ahead, Paul, you can address it.
Yeah, no, that's mostly what we just answered. Unfortunately, if you have a situation where the actual medical expense is cheaper than the capitation payment, the whole capitation payment is due and owing as part of the Medicaid lien. In most cases, it really works the other way, but
it's one of those situations that we don't like, and we will at some point in time have the right case, but it's not been economically feasible for anybody to retain us to litigate that. And a question, there's just not a lot of cases about. There's one reported case. It's not even reported. It was provided to us as a courtesy. So
yeah, and in most of these capitation situations, the numbers are fairly low. And we're really able to get these liens reduced in the traditional ways, which
that's right. That's what we do. Yes.
It's there's other things to consider with respect to Medicaid liens.
And that's really,
yeah,
that's why it becomes most of the time not prudent to proceed in the fashion of litigation, because we will get it done anyway. So Is that it, Kate?
That is what they do. Let's do one more because this one's really good about mixed signals. Last question, number, well, I'm not sure what number. I'm hearing mixed signals on Medicare Advantage plans. Some folks say they have a lien. Others are telling me that they are private coverage, and in New York, private coverage doesn't have a lien. What is my obligation? Is there any case law?
It's a very good question, and yes, there's plenty of case law. It is not a general obligations law situation where it's dismissible. It is under the Medicare statute, and Paul, I'll let you run from there.
Yeah, so it is not a private carrier situation. So Medicare Advantage plans preempt state law by statute under the Medicare Advantage statute. So our GOL is out the window. What we're dealing with really is two things. Number one, you have a regulation under 42 CFR 422.108 sub F, which basically says that Medicare Advantage plans have the same rights of recovery as does regular Medicare under the regular Medicare conditional payment regulations. That's number one. Number two, there's case law all across the country that have upheld Medicare Advantage plans claim for a cause of action for double damages, double the amount owed, for any unreimbursed payments that are related to an underlying liability claim. Those claims have generally been upheld against the defendant's carrier, including in the Third Circuit, in the 11th Circuit, and now in the Second Circuit with the recent decision in a case called Aetna versus Big Y Foods. There are some district courts throughout the country, including, I think, the Eastern District of Virginia, which have upheld that claim again for double damages against plaintiff's counsel for unreimbursed medical expenses in a case called Humana versus Paris Blank Law Firm. To my knowledge, there has not been any cases that have sought or have conclusively enforced the claim against the plaintiff themselves. But it doesn't mean they're not subject to potential litigation or potential claim. Ultimately, under the regular Medicare rules, assuming that regulation that I mentioned is valid, and Medicare Advantage plans do have a right of reimbursement the same as regular Medicare, they do have a claim if they're not reimbursed, potentially against defendant's carrier, potentially against the plaintiff, and potentially against plaintiff's counsel, as does regular Medicare.
And that's exactly what that case said in the Second Circuit. We all thought it would go the other way. We thought that we had some really good opportunity here to say that there is no claim for double damages against a third party who had already settled. Yet in that case, the Second Circuit basically agreed with the other circuits and said, yes, a defendant who has already paid is going to pay again and twice the damages, twice the amount of the Medicare Advantage lien. So that does implicate, in a lot of cases, your indemnification and hold harmless language in your release, because they're going to come back after you if they have to pay where you didn't. So I really think that this is the stickiest area of our business right now, because defendants are certainly not willing to settle cases without a Medicare Advantage determination as to no liability. Thanks.
Wonderful. Thank you so much, Paul and Paul. We really appreciate it. That will conclude our Ask Me Anything session. Anyone with any lingering questions or follow-up, needing follow-up information, please refer to the chat. I did put in Paul and Paul's both email addresses to contact them of Precision Resolution for any follow-up or further questions. If you don't have a pen or can't see the chat, just email the Academy and we'll be sure to get you their info. That is info@trialacademy.org. Thank you again, Precision Resolution. We really appreciate all the help you provide to our members and to our organization. We look forward to seeing you all at our next CLE with you, and also our upcoming membership reception, which you're presenting sponsors of. That's going to be June 22nd in Manhattan. Academy members, stay tuned for those
Well, I
details.
guess I'll just stay here until then.
Yeah,
Perfect.
just can't hang out. There's plenty to do. We got you.
Okay.
Thank you, Paul and Paul, Precision
Thank you.
Resolution.
Bye now.
Take care, everyone.